Hi, this is Richard Bolger. I wanted to do a quick update on the virtual meeting of creditors, which, since COVID, has been done on the telephone, and debtors could appear wherever they wanted, just as long as they had a phone that could mute. They could mute when they needed to. And that process, though, is changing here at the beginning of October 2023. Now we are required, debtors and their attorneys, to appear on camera in a Zoom meeting. My initial feeling on this is that everyone should come my clients should come to my office and do the hearing with me in front of the same camera. So we're in the same room in front of the same camera. And I'll go into detail with that, for my clients when they hire me. But I just wanted people to know that the procedures, the protocols, what have you, for these hearings are changed. They're not in person in Alexandria or wherever now, but they are in front of a camera. So we have to be appropriately dressed and in the same room at the same time in front of the same camera to do it best. It's best to be with me, for my clients to be with me during the hearings. Okay, so I'll add this to the segment about what is the court hearing like, because otherwise all of my advice about how to answer questions, how not to answer questions, etc., is still applicable. Hello again, this is Richard Bolger. So before I begin the substance of this evening's podcast regarding the hearing in your bankruptcy case, I have to give my disclaimer, which is that federal bankruptcy law does control bankruptcy cases. However, from state to state, the practice of bankruptcy law differs because different states protect people's property different, which is, of course, a critical issue in bankruptcy cases. And court opinions can vary across the country depending upon the district and circuit in which your case is located. So I give in these podcasts just general information, how your particular facts might be treated in a bankruptcy case would depend upon you consulting a bankruptcy attorney for advice. Finally, my law firm is a debt relief agency, and we help people file for relief under the bankruptcy code. So I wanted to talk to you about the bankruptcy hearing. For those of you who are my clients and have a hearing coming up, I hope this will help you get prepared. And for those of you who are considering bankruptcy and want to know more about the process, I hope this will give you information about what to expect. When a bankruptcy case is filed, the court will schedule a hearing. Every bankruptcy case, every consumer bankruptcy case, they have a hearing about 30 days after the case is filed. That's true whether it's a Chapter 7 or a Chapter 13. And I will give you some information about how they do vary depending upon the chapter, how the hearings vary. And at the end of this podcast, I'm going to give you my 2 major points that I want you to remember as you consider your hearing. So as I said, the hearing is about 30 days after the case is filed. This is what people call, the clients think of it as court. When is my court date? When am I going to court? In reality, the hearings are administrative hearings, and they're conducted by the U.S. Trustee's Office, which is a part of the Department of Justice. They are referred to as the meeting of creditors. They are a meeting of creditors at which creditors rarely show up. Most of the time, there are no creditors at the hearing because the creditors, if they're institutional lenders, banks, and so on and so forth, they know how to protect their rights in a bankruptcy case without having to attend that hearing. The purpose of the hearing is for creditors to be able to ask questions of the debtor, to see, various issues, explore various issues. But as I said, since creditors rarely appear, the main thrust of the hearing is all about what the trustee who has been appointed in your case is interested in learning at the hearing. So at the hearing, you are going to have a successful hearing if you are well prepared. Okay, it is important that your attorney and his staff adequately prepare you and get all the material that is required for the trustee to be able to fully evaluate your case, because they're going to review the case before the hearing. And the more that they have the required information, the more often they have the required information, the better the hearing is going to go. So, as in all law cases, success depends upon preparation. This is the one event in a bankruptcy case that clients are somewhat dreading, because it is the one public proceeding. Pre-COVID, the hearings were conducted in person. Across the table, there would be a trustee or under oath, testimony is being recorded. Now, in light of the pandemic, hearings are conducted on the telephone. You're still under oath. You still must tell the truth under penalty of perjury, but you are not in a room among a crowd of people. And so you have a little more comfort insofar as you don't worry about who will see you and how do I get there? Will I be late? Where's parking, and so on and so forth. We're doing these hearings now on the telephone. The hearings differ a little bit if it's a Chapter 7 or a Chapter 13. In a Chapter 7 case, the trustee is primarily interested in seeing if there are any assets that they can liquidate in order to sell and pay your creditors. In Chapter 13, the trustee is mostly interested in examining your income and expenses and assets to determine whether you are able to actually successfully prosecute a Chapter 13 case. So the questions that are being posed tend to focus in those areas. Now, the hearing itself, there are typically, say, 6 to 10 cases per hour. So there's not a whole lot of time to spend on any particular case, absent some unusual circumstance in a case. Sometimes they can drag on for a while, but usually you're running 6 to 10 hearings an hour. You are, as I said, you're sworn in, told to. You must tell the truth under penalty of perjury. And then some of the common questions begin. For example, you are asked, did you review your petition with your lawyer when you signed it? Are the contents of the petition true and accurate? Are you aware of any changes that have to be made because of inaccuracies? Have you listed all of your debts and all of your assets? Now, in Chapter 7, the questions will then turn to, do you have any assets? For example, do you own any real estate? If so, what is the value of that real estate? How did you arrive at that value? How much debt do you have against the property? They'll move to automobiles. How many automobiles do you have? Are they financed? They'll look at your bank accounts. The bank accounts, they're going to be interested specifically in the balance on in those accounts on the day your case was filed. People refer to that as a snapshot of your life on the day your case is filed. And what they're looking for is any non-exempt assets. Assets can be protected according to state law, as I referred to at the beginning. And what the trustee is looking for is whether you have any assets that can't be protected. And if so, that's when a discussion will happen with the trustee as to what in the debtor plans on doing about those unprotected assets. It's not immediately the assets forfeited and sold, and that's the end of that. It's just the beginning of a discussion. Is there a way that the debtor can buy out the trustee's interest in the property, for example? In Chapter 13, the questions are more about income and expenses, because the trustee there is looking for the maximum amount of disposable income that he can derive from the person in order to pay the unsecured creditors, typically. And that is, in the context of a Chapter 13, that's a 3 to 5 year repayment plan. It's a reorganization. And as to whether you're a Chapter 7 or a Chapter 13, again, that takes consultation with an expert attorney who knows the difference between the two and what is in your best interest. And what the Chapter 13 trustee is looking for, in addition to returning the most amount of money to the unsecured creditors, is two big issues. One, does the Chapter 13 debtor have the ability to satisfy the liquidation test and the feasibility test? And so his questions or her questions will be designed to elicit information relative to that. What are those two tests? The liquidation test, well, that's where basically the trustee will analyze the case as if it were a Chapter 7 liquidation, and he or she will look to see how much money would the unsecured creditors have received if the matter was liquidated in a Chapter 7. Well, you're going to have to pay that much at least in the Chapter 13 in order to have your plan approved. That's the liquidation test. The other test is the feasibility test. The trustee is going to determine whether you have the ability to fund the plan that you're proposing to the court, because the court's not going to confirm a plan that has pie in the sky goals that are never going to be achievable. For example, if you go into a Chapter 13 because you want to save your house and you have a $300,000 arrearage on it, and meaning you're behind $300,000 in payments, you have to be able to make that up within the next 5 years. And the possibility of that happening is slim to none usually. So that would be a plan that is not feasible. So that gets me to where I said I would lead to, which is my two biggest tips for participating in your bankruptcy hearing. One, you must always tell the truth. Okay? If you're found to be inaccurate or deceptive, and God forbid you're lying under oath, your case is in big trouble. So, number one, always tell the truth. And number two, and this is a huge one, simple answers are the best. This proceeding seems, especially on the telephone, almost as if you're in a conversation. Because, as I said, you're on the phone and someone's asking you questions. And it's a natural inclination for many people to not just say yes or no and stop talking. Typically, they'll say yes and because blah, 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 blah. They'll start talking, answering questions that weren't asked. Remember, you're under oath. This is an inquisition, if you will, and you must tell the truth, but you don't have to tell more than what you're asked. So answer yes or no, or I don't know, whenever possible. As long as it's a truthful answer, that's the best answer. If the trustee wants to follow up or wants to know more about the the issue, the question, they'll ask you another one. Again, keep it simple when responding to every question, and listen carefully to the question. Listen exactly to what you're being asked and only answer that. So those are my two biggest tips. And the hearing, as I said, so long as you're well prepared, you have a good attorney working for you, he has a good staff that helps he or she prepare for your hearing, then you're in good hands. And if you follow my two biggest tips, you're going to be just fine.